All right, good afternoon, everyone. I'm James Pittman, co-founder at Docketwise. Today's August 25th, and this is the webinar on lawsuits to enforce the I-864 Affidavit of Support. I have a very special guest with me. Here I have Greg McLawsen, who's a very well-known immigration attorney who's really made the Affidavit of Support litigation a central area of his practice. And I want to introduce Greg. Greg, please tell us a little bit about yourself, your background, and how you came to focus on this specific niche within immigration law.
Yeah, sure. And James, thanks for the invite. I guess a quick shout out, which you did not ask me to do, to Docketwise, which I've been using, I guess now for, gosh, more than 5 years and absolutely love. So thank you for your wonderful product. I really have enjoyed it.
You're very welcome.
So I've been doing immigration law for a little bit over a decade now. And before doing immigration practice, I did a state court judicial clerkship, which I mention only because it was a deviation from otherwise focusing on immigration law and gave me a couple years of experience doing general civil litigation on the judicial side of things. And so pretty early in immigration practice, working for an ALA attorney here in Washington State, where I'm from, we did a little article for a local bar association, because at the time there was this kind of growing sense in the immigration bar that, gosh, there's this thing, the Affidavit of Support. We've heard that it's enforceable. Are there people out there who are actually enforcing it? And we wrote an article that said, yeah, actually, this is happening all across the United States. Here's how those cases are coming down, and just published this short piece in a local bar journal. As a law clerk who liked doing research, I ended up going out there and reading all of the cases that had been handed down on this, wrote a long law journal article on that. And it kind of went on the shelf, but it also went on the internet. And eventually people started calling me because they were interested in their rights under the affidavit, and nobody out there was actually wanting to do these cases. So they started calling me up because I was the guy who wrote this article, and nobody else seemed interested. And we can talk later about why I think other lawyers aren't interested in this. But ultimately, people ended up calling me because nobody else was out there interested in doing these cases. And so one thing led to another, and I ended up doing more and more of them, and it kind of swallowed the practice.
So this is actually a major focus of your practice at this point.
Yeah, this is the majority of what I do now.
And you are, I would add that you are the sort of the national authority, one of very few people I know who are really totally entrenched in this issue.
That's kind of you.
Okay.
So it's a big fish in a small pond, and by small pond, there's only one fish in the pond. So not that much of an accolade.
But it seems like it's a good pond for you to be in. But Greg, let's talk a little bit about the I-864 Affidavit of Support. It's a document which is an essential part of family-based immigration cases, and it really came to be because there's a public charge inadmissibility ground in the immigration statute when you have to demonstrate that you're not likely to become a public charge in order to be admissible. So the government sort of created this contract. Now, was this the first affidavit of support that was ever created, or the current version, the current sort of I-864, or did it have predecessors?
Yeah, so to go back even further, public charge inadmissibility, which is probably familiar to your listeners, but this is the idea that you have to, as the intending immigrant, demonstrate the ability not to become reliant on taxpayers for support. That idea has been part of U.S. immigration law since the federal government started regulating immigration. So 1882, we see the first public charge provision in immigration law, and it's been basically unchanged ever since. For years and years and years, the sponsor of an intending immigrant could sign what became the I-134 Affidavit of Support, attesting to their willingness to provide financial support for an intending immigrant. The idea being this person has an obligation to show that they won't be reliant on public benefits. Here we have a US citizen showing that they're willing to provide support. But courts held that those old forms, the I-134, were unenforceable. And so what we have now, the I-864 form, came out of some legislation in 1996 where Congress said, and we can go through the reasons why. We don't like this. We don't like the idea that this affidavit is unenforceable. It's basically worthless, legally worthless. And so the new I-864 series was created in 1996, and those are enforceable. No court anywhere in the United States has ever disagreed with that. So that is absolutely settled black letter law at this point.
Mm-hmm. Now it's a contract, and I mean, sort of, I think many immigration attorneys think about the purpose of this as it's something that needs to be submitted with the case, and if the beneficiary sort of accepts means-tested public benefits during the time while this affidavit of support is in effect, then the government can recoup that money. So how did this notion of a private right, I mean, was a private right of action on the part of the beneficiary, was that contemplated in the legislative history? I mean, and what's the, sort of the beneficiary here is acting, would be, in contract law terms, would be a third party beneficiary, because the contract is between the sponsor and the government, or for the benefit of the immigrant. So the immigrant's your third party beneficiary.
Okay, so what was Congress doing in 1996? This was Clinton administration, and there were IRA and PWORA. So there were two sprawling, gigantic public policy questions on Congress's plate. One was IRA, this massive revamp of U.S. immigration law. The other was PWORA, which some immigration lawyers may not be familiar with, but this was just completely gutting and revamping the public benefits / welfare system. One of the hallmark pieces, well, it's hallmark for people in our world, one of the hallmark pieces of PWORA was that public benefits became no longer eligible to recent immigrants. So new lawful permanent residents now lost eligibility for means-tested public benefits for the first 5 years. One of the public policy decisions that got made in this big, horse trading of different concerns was public benefits are taken away from recent immigrants, and this new financial onus is placed on immigration sponsors. So Congress creates this new, and it's not just in the it's not just in the legislative history, it's in the statute itself, a clear private right of action where the intending immigrant, once they gain residency status, can sue the sponsor for financial support. So new immigrant loses rights to TANF, Medicaid, et cetera, but has a new enforceable contractual right for financial support from the sponsor. And you're right that there were two different things that Congress did. Early in the legislative process, the first thing it did was say, we want to make these affidavits of support enforceable by the government. And if the intending immigrant gets means-tested public benefits, the government can sue the sponsor and recoup the cost of those benefits. But remember, I said that at the same time, Congress actually took away eligibility for those same benefits. So yeah, the government has a right to sue the sponsor for the cost of Medicaid provided to the immigrant, but the immigrant isn't eligible for Medicaid. So sponsors never get sued by the government. Why? Well, one reason is probably because the recent immigrants aren't eligible for those benefits.
But it makes you wonder. Let me just add it kind of makes you wonder a little bit, because it was I mean, as a matter of fact, it's hard to find examples of where agencies have actually acted on the right to try to recoup benefits. And as you said, a lot of that is because people who aren't permanent residents aren't eligible for those benefits. But then also it's only a recent phenomenon that the beneficiaries are suing in the private right of action. I mean, that wasn't something that sort of was common of several years ago. I mean, isn't this something which is a fairly recent phenomenon?
Yes and no. So just to affirm your first point, like the lack of agency-based actions against sponsors, those are indeed very rare. I'm aware of one of them in like the past 5 years. There's one case in Colorado, like an unreported, we're talking like trial level decision. But here, like in my state of Washington, our agency that handles these benefits, they don't even have a policy. They don't have a play manual for how they would even handle these lawsuits. Basically, there was just a policy decision that was taken, which is, look, we're just not interested in doing this. We're not going to pursue it, period. And I'm not aware of any jurisdiction anywhere in the United States where sponsors get sued by agencies. In terms of suits by intending immigrants, those actually, there've been a lot of those. So in federal court, there have been significantly over 150, around 200 at this point. And these are just decisions that I can find. I mean, there's no magical way of searching PACER and making sure that you're coming up with every lawsuit out there. And these have been going on for a while. I mean, back when I wrote my first article a decade ago, I mean, there are a lot of decisions discussed in that paper, and that was really before it became more common. So there's no real canonical way for telling how many of these are getting enforced at the trial court level. But what I hear a lot from immigration attorneys is, no, this never happens. And that's absolutely wrong. That is incorrect.
So that leads me to the next question. I mean, for practicing immigration attorneys, when you're advising sponsors, it really behooves you to not just you can't just tell the client that this is a sort of a formality. You've got to really tell them that, hey, there's a live responsibility here. And would you recommend that people who are practicing family immigration, should they do that in writing? Should they have the sponsor sign a memorandum that it's all been explained? What are some of the essentials that they should include in there?
Yeah, I think there's little question that the best practice is at the very least to send your client a letter outlining, and this isn't rocket science. I mean, you could practically pull the language from the I-864 itself. James, you and I were talking before the webinar began. It's right there on page 6 and 7 of the form. Just pull it out there and massage the language a little bit if you want, but get that over to the client in clear English language. And if you want to have them sign off on that as well, that's fine. I think my guess is that the common practice with immigration attorneys generally, not without exception, but I think the common practice is to do nothing. I don't think that attorneys typically sit down their clients and explain what they're getting into. One of the reasons I think that is when I, representing a green card holder, go back to an immigration lawyer and say, we need a copy of your file, and they're not stupid and they understand the reason is because we're trying to sue their other client, the sponsor. They get really, really nervous. And I think the reason they get nervous is because they have an oh shit moment and they realize that they didn't tell their client what they were getting into. So don't be that person. And as you were suggesting, have your 2-page letter that explains what the affidavit is.
And when you start to think about suing on the affidavit of support in the context, especially in the context of a marriage, but of course it could be in the context of any case where it was submitted, a parent, child, brother, sister, etc. But in the context of a marriage, especially, it seems to open up Pandora's box in terms of a morass of questions like, so where do you go to enforce this? Are we going to federal district court? Are we going to state court? What happens if you've got pending family law proceedings in state court? You've got a divorce or a spousal support action going on. And then how does the responsibility of the spouse under the affidavit of support relate to their responsibilities for spousal support under state family law? So, and numerous other questions, but let's just start with some of those. Where is venue property?
Okay. I see that there's some questions about the articles. I think those are going to be posted in the notes to this video when it goes live. I'll also provide a link to my, what's it called? SSRN page. Okay, so venue. Something I hear a lot from judges in state court and attorneys also is this is a federal court matter, and so it must belong in federal court. First of all, yes, it can, of course, be enforced in federal court. There's a cause of action right there in the statute, 8 U.S.C. 1183 A.E.1. And so almost without exception, courts have said, well, here's the Immigration and Nationality Act that says go to court. So that's a federal cause of action. 2 courts have disagreed with that, the Middle District of Florida and the District of Colorado. There was a subsequent scathing decision in the Northern District of Florida that basically said, are you crazy? Like what could be a clearer cause of action? But in the vast majority of federal courts, this can be enforced, no question. We have 4 different circuit level decisions as well that don't directly address jurisdiction, but here you have circuit courts weighing in. When it comes to state court, this idea of federal cause of action, therefore only federal court, I know civil procedure was a long ways away for many of us, but there's this thing called the presumption of concurrency. And that says that if you have a federal cause of action, state courts of general jurisdiction presumptively have the ability to decide those cases. 1983 civil rights claims would be a classic example of that. But even though it's a federal cause of action, unless the federal statute expressly strips courts of jurisdiction, and there's nothing in there that says that, you can go to state court. Aside from that, it's just a contract. So forget about the federal statute, just treat it as a contract and you can go into state court. In reality or in practicality, most of the lawsuits that you see are either federal district court actions or this is brought up in the context of a divorce proceeding. Those are the 2 places where you see it the most.
Someone has a question here, which I think, what about a prenuptial agreement? Is the I-864 beyond a prenup? I mean, can a private contract entered as a prenup have any effect on these responsibilities?
Good question. So the Ninth Circuit has weighed in directly on this and said no, that nuptial agreements and even orders from family courts cannot defeat rights under the Affidavit of Support. And the reasoning really is not that complicated. So this is a right that is created, this right, the financial support right, is created by Congress. And remember that Congress acts at the height of its authority, its plenary authority when it regulates immigration. So if you allowed private parties to do so, you could have anybody sign the Affidavit of Support, and then 5 minutes later, the sponsor and intending immigrant could sign a nuptial agreement that says, ha, 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 no, not really. Everything that was said in that Affidavit of Support, the promises that we made to the government, we're just going to tear up. And the Ninth Circuit in the earlier case in 2016 said, no, you can't do that, that you can't create this end run around Congress for the sponsor. And I mean, think about the power disparities that typically exist in that situation. You know, it's usually, it would be almost like a best practice in any immigration firm for you to have this boilerplate nuptial agreement that you would slap on at the end of an I-864 that says, all of those financial rights I promised I now take away. And the Ninth Circuit says, no, you're not going to be able to do that.
Now, what is so if a spouse is going to court in family court and they're seeking spousal support, I mean, how would the I-864 interact with their responsibilities? I mean, state courts are going to have their own definitions of what's an appropriate level of support. Have you seen family courts take into consideration support that is granted on the basis of the I-864 and factor that into their support award? Or is it the other way around? You're usually getting an order for alimony and support first from family court, and then if you go sue on the I-864, you have to consider whatever alimony you got. And I mean, which way does it work, or both ways?
So when you enforce the Affidavit of Support in federal court, it is ideally clean. You have a cause of action to enforce the affidavit. The damages that you can get are equal to 125% of the poverty guideline minus your income, and that's it.
So that's pretty minimal. So that's really, I mean, that's really minimal. That's only 125% of the federal poverty guideline.
It's minimal, but it's at least clean.
It's clean. That's true. And people who are going to be eligible for that, you have to show that the beneficiary's income was less than 125% of the federal poverty guideline to have this cause of action, to actually have this cause of action heard. Family courts take into consideration totally different factors of what was the level of lifestyle during the marriage.
Right. And that's where I was going with this. So in federal court, like in theory, the damages assessment is straightforward. It gets really complicated in state court. As a threshold issue, there are two different ways it could come up in family court proceedings. Number one is, depending on your jurisdiction, you might be able to plead it as a breach of contract action, because family courts are typically a branch of a court of general jurisdiction. So you could say, forget about alimony. We just have a breach of contract action involving the same parties. Permissive joinder lets us bring it into that same case. But how it typically gets involved is as a factor to consider in connection with alimony. And there, and this is, James, what you were indicating, states have these like multi-factor tests of what do we consider when we think about alimony awards. The standard of living of the parties is typically one, the relative financial positions of the parties. So one of the problems you get into there, and this was addressed here in my home state of Washington, is can a court even consider the affidavit of support? Because typically those multi-factor tests don't talk about contracts between the parties. So in the matter of con decision here in Washington state, a court of appeals said, this just doesn't figure into our alimony considerations because it's a contract that's not included in our multi-factor decisions. However, you've got cases like states like North Carolina, big ones, California, Texas, all of which have said, we will consider this in the context of awarding alimony. And then you're absolutely right that you get into this question of like, how do the plain contractual terms of the affidavit interface with the kind of equitable, mushy factors of alimony decisions? And what I will say there is that's when things get weird. And we haven't talked about it yet, but the affidavit of support obligation goes on until 5 terminating events defined in the affidavit. But you have family law courts looking into their crystal ball of equity and saying, well, in the interest of fairness, I'm going to limit the duration of support until 36 months or whatever.
Well, let's get into that a little bit. You talked about what terminates the affidavit of support, because I want to sort of go into that. Let's talk about what the terminating events are.
Yeah, so there are two that really matter. One is the intending immigrant becoming a U.S. citizen, which, by the way, they never have a legal obligation to do. Don't be confused about that. And number two, being credited with 40 quarters of work, which is to say 10 years under the Social Security Act. The other three are uncommon, so losing U.S. residency and departing the United States. Note that losing residency by itself is not a terminating event. So if you have, and we have had these cases, somebody who, oops, forgets to file their I-751 and status is terminated and they're in proceedings, the affidavit of support is still enforceable. Because remember, the whole purpose is to provide support while they are here, not wanting to be reliant on public resources. So loss of residency, even a final order of removal, doesn't terminate the affidavit. Number four is that if the person readjusts in removal proceedings, that terminates the affidavit. I've looked at 500 or 600 of these cases. I've never seen one of those. And then lastly, if the intending immigrant or the sponsor dies, there aren't too many dead plaintiffs out there running around, so that doesn't typically come up either.
Let's talk a little bit about it as a contract. So in a contract, we all remember from first year law school, you have to have meeting of the minds and you have to have consideration. Each party has to give up something in order to make the promise legally enforceable. What is the sponsor giving up, and what is the promise on the part of the sponsor? What's the promise on the part of the government?
Yeah, and courts do address that, which I will do also in just a moment. I will also say that I've become increasingly skeptical that this question actually matters. Why? Because at the end of the day, the I-864 and all immigration doctrine is an exercise of the plenary power, which is Congress operating at the height of its authority. It can do basically whatever it wants. And remember all of the terrible things it's done, over the years. If Congress wanted to write a law that said, when you sponsor an immigrant, you sign your name on a potato and throw it on the barbecue, burn it up, and then eat it, you've created an enforceable contract. That's probably enforceable because Congress, again, can do effectively whatever it wants in immigration. So I'm not sure that the common law requirements of the contract actually matter.
Got it.
With that being said, what courts have said is that what the sponsor gets for return consideration, and this is again in the affidavit of support itself, is the intending immigrant becoming a resident. Basically, the government says, you sponsor obviously want this person to become a resident. Why? Because you filed a petition for him. Well, you can't have that unless you also sign the affidavit of support. So our return consideration is granting residency in exchange for the affidavit.
So does that mean that, so it's not forbearing on applying the public charge ground of inadmissibility, it's the granting of the residency. And so when does it actually enter into effect? Does it enter into effect on the date that it's signed, or does it enter into effect the date that it's submitted to USCIS, or the date of that USCIS grants the person resident status?
So there are two different things, and this is resolved in the federal regulations at 8 CFR 213A.2. The contract becomes an enforceable contract. It is considered executed when it is signed and filed in support of a visa application or adjustment application. So then it's a contract. But there's a condition precedent to the sponsor's obligation, and that is the event of the intending immigrant gaining residency. So contract once the thing is signed and filed, but the obligation begins after and on the date when the intending immigrant becomes a resident.
Okay. I'm looking at, we have a couple of questions.
Yeah.
Let's see if we want to take a few questions here. What consequences would an attorney face when and if the clients are not explained about the I-864? Well, you know, you are failing to adhere to the I mean a standard of competence by doing that, and you could I think be accused of being negligent in your responsibility if you fail to certainly someone could file a complaint against you. Greg, have you seen anybody any of these situations? I don't know firsthand.
I haven't, but I do think it's just a matter of time.
Right. Next question.
And I tell you,
Okay.
I think the most likely place where this is going to come up is joint sponsors, which has been a very small drum I've been beating for years.
Let's talk about that, because I was actually going to get to that, but now that you brought it up, I want to ask it. So I mean, you have a, if the petitioner does not have sufficient amount of income, one of the ways of overcoming that problem is to have a joint sponsor, or they can use a household member. Now, my understanding is all of those additional parties who are signing either the I-864A, or in the case of a joint sponsor, a separate I-864, those are all jointly and severally liable. Is that true of the household member too? They're promising, the household member's promising the sponsor something on the I-864. Are they also promising?
Yeah, I mean, I think some like staff attorney at Legacy INS got a little bit too carried away on this and made it more complicated than it needs to be.
Okay.
The I-864A is a contract between the sponsor or joint sponsor and household member. But at the end of the day, joint sponsors and household members are all jointly and severally liable to the intending immigrant. So regardless of how like the network of obligations flows, ultimately they all go to the intending immigrant.
Have you seen real situations where the joint sponsor and or household member have actually been forced to provide support in these enforcement? Yeah. Okay.
Oh, I mean,
and
I
how
have at least 6 of those cases going on right now.
How does that work out? I mean, does the court first try to get it as much as it can from the petitioner sponsor, and it only moves on to the other parties if that person doesn't have enough resources, or what happens?
No,
or do they just go for the first person that they can get a hold of?
Joint and several means we can go after only a joint sponsor if we want to, or both, or none. You the plaintiff have the choice.
In practice, would you name all of those defendants and get an order covering all of those, and then you proceed to enforcement or collections based upon who's available? Or?
Yeah, well, so speaking of practicality, these claims, as with most civil claims generally, get resolved amicably. Well, that might be saying too much, but they get resolved in settlement. Because especially, and we'll talk about affirmative defenses later, I think, but especially in view of cases that hold that there aren't any contractual defenses available, You're making a big mistake if you, the sponsor, want to spend 2 years litigating this in federal court instead of penciling out a settlement obligation in a situation where the underlying legal duty is to provide poverty level support. I mean, we're not talking, the underlying obligation here is not something that bankrupts people.
Mhm.
So
But 2 years of attorney's fees plus court costs could.
yeah, so there is a fee shifting provision in the statute. Courts consistently award fees to the plaintiffs in these cases. The high water mark in that case is a case we had in the Central District of California, which went to a jury trial after we spent a long time throwing settlement offers at the other side that were knocked down and knocked down and knocked down. And the federal district court awarded just over $250,000, $250,000 in attorney fees. So that's a bad resolution. A good resolution is paying $1,400 a month, for as long as you need to.
Let's talk about the, well, actually, let's return to our questions and see if we have, okay, so in terms of calculating the damages, so you're going to calculate based on 125% of the federal poverty guidelines, but is it, a couple of questions about this. So if, let's say that the beneficiary has been below 125% of the poverty guideline for a couple of years, like a year or two before they bring the action for the support, are they entitled to go back and get the support for the years in which their income was below the threshold? And or simply is the sponsor going to be on a hook for the year that they file the action? How would that work? And someone else has asked a question of, would the amount awarded be until either party dies, the beneficiary becomes a U.S. citizen, beneficiary works 40 qualifying quarters? So in the terms of the order, is the order going to spell out that this is an ongoing obligation and it's only going to terminate upon one of these events? And then if one of those events occurs, then the sponsor is going to go back and file for a lifting of that order?
So there are basically two forms of relief a plaintiff is seeking.
Okay.
One is an award of damages. The second is an order of specific performance. The damages address all of the support obligations that have obtained up to when the judgment is entered. So whether we have 3 months when support should have been provided, or 3 years or 6 years, you look back on a year-by-year basis because these are calculated annually, not aggregately. And for every year, you do math. And the math is, what's the difference between 125% of the poverty guideline and the person's income? Add it up for 1 year, add it up for the next year, and that total amount is your damages. The future is uncertain, though. We don't know how long the person is going to be reliant on support until one of those 5 terminating events is met. And so the court orders specific performance. And typically what the judge will do, like Judge Estudillo in Washington here a couple months ago, will say, check in every month. You, the plaintiff, tell the sponsor what your income's been, and they will cut you a check. That is the difference between your income and 125% of the poverty guideline.
And okay, all right, fair enough. Let me see, what other question? Oh, I had a question before I forget it. I don't want to forget my question, which was the question of, so we talked a little bit about how the state contract principles aren't really all that important because it's really a federally, statutorily created set of obligations that we're talking about, and it's a plenary power. So what about the doctrine of federal preemption? I mean, you would think that if Congress has spelled out these obligations in the statute and in the regulations, have there been any cases where state courts have held that they should not have jurisdiction because it's field preemption on the part of the federal government?
Oh, should not have cause of action?
Yeah, should not have jurisdiction because of
okay.
federal preemption.
So the way that comes into play, there's never been a case that held jurisdiction was limited. Where that comes into play is in the field of defenses. Because normally in contract law, I think I threw away my 1L Horn book, but there's this whole laundry list of affirmative defenses to contracts. The one that comes up the most in affidavit of support litigation is fraud. This is alleged by almost every defendant I see. And the idea is, she never loved me. She married me for a green card. Ergo, the whole affidavit of support is void or voidable, and I have no obligation. And federal courts have, with increasingly consistent clarity, said, we don't buy it. The first case was the Leo v. Mund case out of the Seventh Circuit, and it addressed the mitigation of damages doctrine, another common law doctrine, which in its normal application would say that an intending immigrant has an obligation to seek work in order to limit damages under the affidavit. The consequence would be that you would reduce recoverable damages by whatever money the person had the theoretical ability to earn. And Judge Posner, if that rings a bell for anybody, the 10th Supreme Court Justice says no, that there's nothing in the statute. So this kind of goes to your preemption question. There's nothing in the statute that supports the idea that there's a duty to mitigate. And so we're not going to read one in there. And that we don't care if there's a state common law doctrine of duty to mitigate. It's not in the statute. So it's not there. And there has been a whole chain of decisions that have expanded that holding to say that contract law defenses just don't apply in these actions. And that includes this affirmative defense of fraud. So we, the federal judge, are not going to sit and play Monday morning quarterback about whether she ever really loved you. This isn't about that. You signed the contract, they gained residency, it's enforceable, period, regardless of what doctrine might otherwise be applicable in state common law.
Okay. Well, let's talk about some of the other defenses. So you've talked about. So what are some of the defenses that you've seen attempted that have not worked? You mentioned fraud. How does that actually come up?
Well, I mean, going back to civil procedure. So, it'll be pled as an affirmative defense. We, over the past 5 years, we've basically had universal success fighting that on a motion for judgment on the pleadings, which is to say that we simply go to the judge and say, Judge, there is no set of facts that could present a cognizable defense here because fraud is just not available to I-864 sponsors. And so let's not get into discovery, because what sponsors want to do is get into discovery on every malfeasance that's happened in a relationship, what a bad person the intending immigrant was, blah, 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 blah. And federal courts will shoot this down before it even gets to that stage. The Ossolino decision in North Carolina federal court would be a recent example of that. and Belovich out of the 11th Circuit is the most recent circuit level decision.
I mean, looking at my little crib sheet of contract law defenses, doesn't seem like really any of the other ones even really apply. I mean, you can't claim unconscionability. It just
they've tried. Yeah, so even back I think it's fair to say that the majority opinion in federal court is that affirmative defenses, contract defenses, just don't apply categorically. Before you had that line of cases, there were courts that would look on a case-by-case basis about those particular defenses. And even when they get into the nitty-gritty of unconscionability, they reject it because they say, what's your argument, sponsor? Your argument is that you sign the affidavit in order to get this person into the country, and you're saying that the obligation placed on you is unconscionably onerous in terms of what you got. And courts say, no, you entered into this contract, you got exactly what you asked for, and you don't like, the obligation that came out of that. That's not unconscionability. That's just, you don't like the benefit of the bargain that the government got.
It would seem that it would not be unconscionable, given that the disclosure is there in the form and it's voluntarily entered into. So
Because
Miss,
unconscionability doesn't typically require a weighing of, did somebody get enough in return? Usually a peppercorn is enough.
exactly.
And here you got your spouse, sister, brother, mother, residency.
Residency in the US, right?
No.
Mistake. Again, hard to see how you're making a mistake when you're signing your name to a form which has numerous paragraphs explaining what the responsibilities are. Has mistake been tried as a defense?
I can't think of a case in the past 7 years or so that's done that.
And usually a unilateral mistake is not even, my recollection is a unilateral mistake is not a defense to a contract. You would need a bilateral mistake. So I don't even see how that, I'm not sure how that would be possible. Maybe somebody will try it, but
Yeah, I mean, one that's been raised by a defendant in one of my cases, which didn't make it into court, was basically not fraud in the inducement. What is the other one called?
undue influence,
No, where you
duress.
keep them coming. Where you're presented with document A, but it's actually document B. So the person,
yeah, I can't
about.
think of it. I know what you're talking about. I can't.
So the
think of
person basically said, I didn't know what it was I was signing, and there wasn't even enough of a toehold on that, for them to plead it and get past Rule 11.
How about duress, undue influence? I just don't see.
Well,
It's hard for me to even think of a hypo where you could come up with that argument.
I mean, to give you the battleground of where this is actually fought, and this goes partially to a question somebody was answered. The actual defensive battleground is typically staked out on two issues. One is fighting over what the immigrant's income was, and number two is the 40 quarters issue.
Okay.
So the 40 quarters issue comes up because it's not simply whether the immigrant has worked 40 quarters, but whether they can be credited with 40 quarters.
What's the difference?
The difference is that the Social Security Act allows you to be imputed with quarters of work from your spouse. So defendants in cases where people have been married for 5 years or more want to argue, we've been married for 5 years, let's just say they've both been working, 5 years plus 5 years equals 10. Or they will be arguing that somebody was working under the table or worked under a past Social Security number. They'll be trying to find a way to demonstrate that there are 40 creditable quarters under the Social Security Act. And then ditto with income, the argument will be that there is unreported income, because like in our complaint, we will always attach a copy of the person's tax records. And then the defense will be, yeah, okay, that's your reported income, but we think there was other income, doing Uber rides or working under the table, doing nails, blah, blah, blah. So that's really where you get into the nitty gritty of defenses in these cases, are those two issues.
But how is the 40 quarters, the creditable 40 quarters, how is that playing out? I mean, are they in fact taking all the quarters that the spouse worked and offsetting or crediting those to the beneficiary, I should say?
So no, for two reasons. Number one is that you can be credited, you meaning anyone, can be credited with only a maximum of 4 quarters per year. So at most, you can get 4 quarters per year. It doesn't matter if you and your spouse are working. But number two, and this is the real kicker, the Social Security, the INA provides that credit happens only so long as the parties, quote, remain married. And in all of these cases, the parties are either already divorced or they're in the process of getting divorced.
I see. Okay, so that's important to know. Someone asked the question: is there a good resource that sort of explains and teases apart how to calculate what quarters someone can be credited with? It's got to be in the federal regulations.
Well, it's in the Social Security Act's POMS, POMS. Okay. That's the Social Security Act's. It's like their policy manual.
Yes.
To use CIS terms, POMS has all of the nitty gritty on quarters of work calculation. The starting point, though, is you can just request your Social Security statement. That's the easy way to get going.
Someone's asked another question, which I want to get to. It's a short question. If somebody has a final order removal and is outside the country, is there a way to have them enter the U.S. and appear at a federal court hearing in an enforcement action? Must they appear in person? Can this be enforced by beneficiaries who's abroad?
Yeah. Well, I wish I could talk about it. I have a matter right now that will present that issue squarely. But the closest I've come in the past is situations where somebody was here in the United States on LPR status, went home to visit parents, usually when a relationship went south, and then re-entered on LPR status. And that we've had plaintiffs able to recover support that included the period of time spent out of the United States, because there's nothing in the contract or in the statute that requires the person to be here. Now, final removal order and outside of the United States, that contract has of course been terminated, because that's the third terminating event: loss of LPR status and departure from the United States.
There you go.
But you could still potentially recover support for the period before the contract was terminated. Never seen a case like that though.
That's interesting. Yeah, you would. That's very interesting. You could possibly still get support for the time period that they were here. Is it correct that we've said that there's no legal obligation on the beneficiary to naturalize? There's no law that says that people have to go look for a job.
Right.
Does the sponsor have any sort of claim at a future date if the beneficiary just purely does not avail themselves of opportunities to either naturalize or earn an income?
No, because
Okay.
number one, the immigrant is not a party to the contract. And the way contracts work is that you cannot owe legal duties to a contract that you are not a part of, right? If James goes out and signs a contract with the government, he cannot force me to incur legal obligations. That's what it means to not be a party to a contract.
Okay. Let's see here. Someone has said their understanding is that you can ask the Social Security agency to merge the earnings of a fake Social Security number with a new Social Security number. Could the earnings of the fake Social Security number be included in the 40 qualifying quarters? Any idea, Greg?
That's an untested battleground.
Okay, we're not sure.
There's no federal or state case that addresses that issue.
What would the impact of an annulment be on a potential I-864 enforcement action? Hypothetical: foreign national and petitioner marry, foreign national gets their green card, then petitioner files for an annulment which is granted. Green card is no longer valid.
So this is another untested question, but following the line of cases that talk about affirmative defenses, this would not be a defense. And the reason is that the affidavit of support is treated as a strict liability mechanism. Remember that the reason we have the affidavit is to provide financial support for recent immigrants after they are brought into the United States by a sponsor. And the idea of not allowing fraud as a defense in these cases is that it doesn't matter. You sign the affidavit, the person's here in the United States, and that obligation is on your shoulders. And that same line of reasoning would apply in an annulment. That it's like a Chicago school economics least cost avoider question. Like, you, sponsor, were the person who had the opportunity to weigh the pros and cons of this and make a decision. The American public sure didn't. So you brought this person into the United States, you made the wrong call about the validity of that marriage. Tough nuts.
How about, I was thinking, what has anyone ever tried a force majeure kind of defense?
Yes.
Suppose the petitioner lost their job during the COVID pandemic or something. Would that be a force majeure?
So no to that, and the income of the sponsor is not relevant. So sponsors all the time will say, I'm not liable because my income fell. Well, tell me if that's how credit card agreements work, because in my experience, you don't get to call up the credit card company and say, hey, I incurred this big liability, but I don't have the ability to pay it. And the credit card company doesn't say, oh, well, that's too bad for me. No,
Right.
it doesn't work that way. The closest that's come up was an impossibility defense, which actually was approved. This was before the line of cases that said no affirmative defenses. And the defendant said, hey, look, this beneficiary hid from me. I think it was in Egypt. Stayed outside of the United States. There wasn't a way for me to get in touch with them. And there wasn't a way for me to comply with the support obligation. And in that one case, federal case, the court agreed and said, yeah, if you legitimately don't have a way to provide the financial support, you're off the hook. But that was a very isolated set of circumstances.
Understood. Another interesting question someone asked here, what about if the damages are calculated based on the beneficiary's income compared to 125% of the poverty line, but what about if the beneficiary has assets? Do we have to offset the income with those assets?
Yeah. So the deeper question here is what we mean when we say income.
Right.
And unfortunately, that is one that has really vexed federal courts. The federal regulations, in my reading, define income to mean taxable income. And that provides us with maybe a definition that is imperfect from a policy standpoint, but it sure seems to me that that's the decision Legacy INS made. And we've had a line of cases over the past 2 years that have agreed and have said taxable income is how we measure income. There's another line of cases that says income means, well, I don't know. Income means any financial source available to the immigrant.
Right.
If you follow the narrow regulatory definition, no, assets don't qualify to offset income because assets are not income.
Assets, they're just not.
If you follow this, like, I don't know what to do approach to income, I don't know. I guess maybe assets are income, maybe anything is income. I don't know. I don't know what a court would do in that situation.
That seems to be something that had not been contemplated. It almost looks like it's a kind of a hole in the scheme here, where they just didn't contemplate. I mean, if you had a beneficiary who has a significant amount of assets, but they don't have an income and they are not seeking an income, but you've still got the petitioner on the hook under the affidavit of support. It kind of seems like that's something that I'm just hypothesizing that might not have been completely thought through. So where you've got income defined narrowly, but they have access to other resources.
Yeah, which goes to, classic questions of statutory and regulatory interpretation, which is, do we try to divine what it was that Legacy and INS or Congress in 1996 would have wished, or do we try to identify the justiciable rules that do exist in the statute and do exist in the contract and apply those to whatever result follows? You can tell that I'm in the second category. So, if Legacy INS defined income to mean taxable income, and the obligation is tied to taxable income, well, that gives you your result. And it's not up to federal courts to decide whether that seems fair or desirable. If now CIS or Congress doesn't like that result, they can go back and change the statute or regulations.
Mm-hmm. Yeah, it would be a technical correction on their part, and they've done countless of them.
Oh yeah, all the time.
Let's see here if we have. I think we've answered all the open questions. Let me go back to my sort of notes here. And I had a hypothetical for you. Let's look at how I came up with this. So let's use an example of a marriage case, right? And then a classic VAWA fact pattern. The marriage breaks down at a certain point while the case is still in progress. The parties separate, the beneficiary files an I-360, and then under the VAWA, and they adjust based on the approved I-360. So an I-360 does not require an affidavit of support. So does that then remove, because they're adjusting and they're getting residency based on the I-360? Does that void the I-864?
Let me do you one better than a hypothetical. So we had a case in federal court where that happened. And this, by the way, comes up all the time, some version of what you were just talking about, because the vast majority of these affidavit cases involve some form of abuse. That's, marriage is broken down. Those are the people who end up enforcing this. The folks we had, Filipino gal, married, marriage kind of starts falling apart while an adjustment application is pending. She goes off and gets pro bono help, files the I-360. The the adjustment case is fully documented. We've got the I-64, we've got tax records, the I-360 gets filed. All of that gets thrown at the local field office. So our gal gets called in for an interview on the I-360, and the adjudicating officer has the original adjustment package, which was from a K-1 adjustment, and the I-360. Ends up approving the I-360, but also approves the I-485 as predicated on the K-1. Now, you are right that if status had been granted on the basis of the I-360, I-360 doesn't involve the affidavit of support. And so there's no corresponding right to financial support. But what happened in this non-hypothetical case I was just describing is that status was actually granted. Even though there was an approved I-360, status was granted on the original I-485 tied to the K-1. And so she was then able to turn around and file an enforcement action against her sponsor that we prevailed on. But
Interesting.
You're right that if you do, and this happens too often, if you pivot strategies over to the I-360, then you're gone.
Okay. I think you've already answered this one, but I'm going to just state it for clarity. So if you're in divorce proceedings in family court and you've got you've got a resolution of your case, you've got an order for alimony and support in the family court, is anything precluded if you didn't raise anything about the I-864 while you're in divorce or support proceedings? Are you waiving any rights if you later decide to go to federal court?
Not in the Ninth Circuit. The way I read the earlier decision from 2016 is even if your divorce final orders expressly tries to waive support under the affidavit, that would be ineffectual under Erler. Now, outside of the Ninth Circuit, there's not clear case law on that. What I advise folks is, unsurprisingly, not to delay. So usually when I'm contacted, it's while a divorce is in progress, and I say, let's get out the gate, go file the federal district court action, specifically to avoid the res judicata argument / waiver argument, which I think is ultimately going to be a loser. But it's like, I'm always happy to deal with fewer rather than more legal objections from the defense.
Understood. Let me ask a policy question while we still have a few minutes. So first of all, I gather you think that this type of litigation is going to become even more common. It's starting to become something that people are really talking about. If that is the case,
they're talking more and more about it.
They're talking more and more about it. That's correct. And do you see that, or is the number of these types of actions filed, is that increasing year by year? Can you tell?
I mean, the problem is I guess I could submit a FOIA request to whoever handles ECF, the court administration. I forget what the agency is called. But just in terms of like readily accessible data, there's really no way to tell.
Okay.
I mean, I can say that my intake funnel spiked during COVID because,
not surprising,
we were just seeing so many marriages falling apart, so many
people losing their jobs.
So that's something I'm inclined to attribute to COVID more than just kind of a general groundswell of cases.
Do you think that sort of increased enforcement, if this does become something that's a common type of action, will that discourage people from becoming sponsors? Do you think it's something that Congress would need to revisit, or do you think the policy consideration should come into play at all?
I hear that objection all the time from immigration lawyers, and I think it's a real red herring. Why? Because the actions that are brought are typically by former spouses. And the idea that you wouldn't get married or wouldn't want to live with your spouse, because if you get divorced and the person is unemployed, they might be entitled to poverty support from you.
1.25 of
Like
the poverty line.
that's a marriage you probably shouldn't get into, right? I mean,
Yes.
the idea that if a marriage falls apart, you might have a financial obligation, that's not news to
Right.
anyone, I don't
To
think.
anyone, certainly shouldn't be.
But yeah, if you have a client who's saying, I don't want to bring my fiance in on a K1 because I might eventually have to pay him to help them survive above poverty guideline for a few months, that should be a big red flag for you. Like,
right.
who are your clients there?
I agree with you. I think it's verging on being a throwaway argument, actually.
You would think so, but I hear this all the time from immigration attorneys.
Somebody asked about a hypothetical. If the person's coming in on a K1, they would have had an I-134 filed with the consulate. Is that not enforceable? And we said at the beginning of the session that the I-134 is not an enforceable contract.
Right. But remember, of course, that the I-864 is going to be filed with your adjustment packet.
Correct. And so there would be, if you had the I-864 submitted, you wouldn't even have to cite back to the I-134 because it doesn't really add anything.
No.
If the beneficiary remarries and the new spouse earns more than 1.25% of the poverty guideline, does that income get imputed onto the beneficiary?
So again, results may vary, but under that earlier decision in 2016, household refers to the individuals sponsored on the affidavit and not anyone else. So you have a strong argument under Erler that for damages, we look only to the sponsored immigrant, and we don't care as an Erler if she's living with a son who has income over the poverty guideline. The only person whose income we're considering is the sponsored immigrants.
Good to know. All right, well, we've answered all of the questions, and those were really good questions, by the way, audience. We're at the end of the hour. I hope that this has been very informative. I certainly think this has been extremely informative, and I want to thank again Greg McLawsen for participating in this webinar. It's been a pleasure. This has been a great discussion, and it's going to be very interesting to see how this area of litigation evolves over the next couple of years. We are going to post Greg's articles along with the video. There will be a video available of today's session, and Greg's articles will be linked there, as well as links to some of his media channels. So please look for that as well, and please come to our next webinar.
And I'll just offer open.
Sure.
I think a lot of folks aren't familiar with these issues. If anybody has questions about the affidavit, they're welcome to reach out to me. I'm happy to answer individualized questions. Also happy, you can just pick up the phone and call me if you want to kind of figure out what's going on with a potential client who you think may have a claim. I'm happy to just talk to you won't charge you. You can just pick up the phone and call me.
Can't see better. Can't ask for more than that. That's excellent. Thanks, Greg. Much appreciated.
Sure. Thanks for the invite.
Thank you. Bye-bye.
Bye-bye.